Hello friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on fundamental rights versus directive principles of state policy. On behalf of the content writer Dr. K. Sita Manikayam, assistant professor, Dr. B.R. Ambedkar Law College, Andhra University. This unit will aim to fulfill certain learning objectives, which include: number 1, understanding the way in which fundamental rights and directive principles are related to each other. Number 2, an appreciation of the role of the judiciary in strengthening fundamental rights and directive principles. Friends, with these learning objectives in mind, let us now try and understand the basic issues concerning fundamental rights and directive principles of state policy. Fundamental rights and directive principles of state policy are enshrined in the Constitution of India, and they are collectively seen to embrace the human rights of any human being. The plan of constitutionally personified basic rights emerged in India in 1928 itself. The Motilal Nehru Committee report of 1928 clearly envisaged inalienable rights derived from the Bill of Rights enshrined in the American Constitution to be accorded to the individual. These undeniable rights are conserved in Part 3 of the Indian Constitution. The theory of directive principles entrenched in the Constitution was motivated by and based on Article 45 of the Irish Constitution. The directive principles obligate a duty upon the state not only to acknowledge the fundamental rights of an individual, but furthermore to achieve certain socio-economic goals. Directive principles were enumerated in Part 4 of the Constitution. Towards implementing the ideals and to achieve the goals enshrined in the preamble, as well as to establish a welfare state, fundamental rights and the directive principles of state policy have been provided in the Constitution. The perception of social justice, which is enshrined in the preamble of the Constitution, contains the target of the people of India. This preamble of justice has been translated in various provisions in both Part 3 and Part 4 of the Constitution, mutually having a common grounding between fundamental rights and directive principles. In fact, together these sets of rights owe their basis for the freedom struggle waged by the Indians against the British regime to defend Indian culture, values and association. The major purpose of the British rule in India concerned largely with the exploitation of the resources of the country and hampering its integrity. It caused breakdown of all kinds of Indian structure, civilization and wealth. This state of interactions led to the thoughts in the minds of the Indians that those socio-economic circumstances of the people cannot be enhanced or improved unless there is a revolution in the government and its administrative setup. This led the Indian community to comprehend that the answer lies in political freedom and the Indianization of national setup. Friends, to accomplish the pledges and commitments, hopes and aspirations of pre-independence age, the foundation prepared apparent provisions for fundamental rights and directive principles for state policy. Fundamental rights are definite rights without which a human being cannot endure in a noble manner in an enlightened society. Fundamental rights are known as basic rights or permissible rights. They are also called as personal rights or negative rights, and inflict negative obligations on the state, not to infringe on the independence of the individual. Articles 12 to 35 of the Constitution provide for various kinds of fundamental rights. Similarly, Part 4 of the Constitution deals with directive principles of state policy. These directive principles, in fact, contain affirmative rights and compel positive obligations on the state. The directive principles are therefore categorized under three heads. First, Social and Economic Charter. Second, Social Security Charter. And number 3, Community Welfare Charter. Within the Social and Economic Charter, Article 38(1) provides for social justice, and Article 39(d) provides for equal pay for equal work. Under the Social Security Charter, Article 43 provides for worker participation in the management of the factories. Article 45 insists on free and compulsory education to all children up to the age of 14 years. And Article 39A, as inserted by the 42nd Amendment, provides for equal justice and free legal aid. In Community Welfare Charter, Article 44 envisages Uniform Civil Code, and Article 48A, inserted by the 42nd Amendment Act 1976, deals with the protection and improvement of forests and wildlife. Friends, let us now look at the difference between fundamental rights and directive principles of state policy. Parts 3 and 4 of the Indian Constitution were formally described by Chief Justice Chandrachud to be the conscience of the Constitution in Minerva Mills versus Union of India. Though there has been perennially a debate adjacent to the constitutional correlation between fundamental rights and directive principles, as there would be a clash linking the interest of an individual at the micro phase and the community's benefit at a macro phase. The innermost part of this controversy is the query pertaining to which component of the Constitution would dominate in the case of a contradiction between parts 3 and 4. The directive principles of state policy vary from fundamental rights in the subsequent respects, although both intend to ensure contentment among the common people. Number 1, fundamental rights are destined for the citizen, while directive principles of state policy are predestined for the state. In supplementary words, fundamental rights are personal and meant for individual people, while directive principles of state policy are socialistic in character and desire to create equality and justice in the society. Number 2, fundamental rights are enforceable within the courts. Person can move to the court looking for legal assistance if fundamental rights are usurped by the state. Lying on the other hand, directive principles of state policy are not enforceable, and no one can go to the courts to induce the state for their appropriate execution. Number 3, the courts are bound to state as void, with certain exceptions, any law that conflicts with any of the fundamental rights. On the other hand, for directive principles, the magistrate cannot proclaim as void any law which has inconsistency with any of the directive principles. Number 4, fundamental rights are involuntarily enforced, while directive principles, on the other hand, require legislation or policy intervention for their appropriate execution. As there is no law in carrying away the policy laid in the directive principles. Number 5. Fundamental rights look forward to establishing political democracy, while directive principles seek out to establish social and economic democracy. In other words, fundamental rights are political in nature. These rights warranty some democratic rights to the inhabitant. On the other hand, directive principles are economic in character mostly and desire to ensure the social and economic security of the people. Number 6. Fundamental rights are claims against the power of the state. Since they denounce state's freedom to use its power indiscriminately, they are negative in their nature. On the contrary, almost all the directive principles are positive in character, as they are like positive commands that the government at all levels must go over to contribute to the establishment of social, democratic and economic system in India. Number 7. With the imposition of emergency, the function of the fundamental rights, except Articles 20 and 21, can be suspended. But no such requirements are required to be made about the directive principles of state policy. Number 8. Article 32, Clause 2 prohibit the state to create any law which takes away or abridges the right conferred by Part 3 of the Constitution. But no such categorical restriction on the power of the state is provided regarding the directive principle of state policy. Number 9. Fundamental rights are not absolute and society is subject to coherent limitations. On the other hand, directive principles have no subject matter to any constitutional limitations. Based on the political determination, the government may or may not put into practice these principles. Number 10. The conflict between fundamental rights and directive principles, it is held that the previous will get primacy by the court. Every legislation prepared to execute directive principles of state policy is a matter of study by the court to decide whether it is impulsive of the fundamental rights, especially Articles 14 and 19. 11. Fundamental rights are further precise and tangible, while directive principles are universal in nature and are of wider impact. Despite so many differences, fundamental rights and directive principles are closely connected to each other. Both the concepts constitute an indispensable part of the Constitution and are fundamental for the proper development of our country. Although directive principles are non-justifiable, this does not imply that their implementation has been left at the will and mercy of the state. Directive principles are part of the Constitution, and the judiciary is under obligation to maintain the supremacy of the same. The Supreme Court of India has resorted to provisions relating to the directive principles while delivering its verdict in a number of cases. The primary distinction between fundamental rights and the directive principles, as visualized by the drafters of the Constitution, has been with regards to the question of whether they can be enforceable. Part 3 of the Constitution was enforceable against the state, but Article 37 expressly provides that Part 4 cannot be enforced in a court. Early Supreme Court decisions recognized the supreme value of fundamental rights based on this aforesaid difference. In the landmark judgment of State of Madras versus Srimati Champakam Durai Rajan in 1951, the court held that directive principle was specifically made unenforceable by Article 37 and therefore could not supersede the fundamental rights found in Part 3, which was enforceable pursuant to Article 32 of the Constitution. The court opined that fundamental rights were sanctified and may not be condensed by directive principles, and asserted that the directive principles, even though significant in their own esteem, were requisite to hold on to the fundamental rights, and in the case of conflict, Part 3 would succeed over Part 2. This observation of the Apex Court was reaffirmed in a subsequent landmark decision of Muhammad Hanif Qureshi versus State of Bihar in 1958, and in another case, in Re Kerala Education Bill case 1957. These decisions of the Apex Court faced too much criticism due to the excess relevance provided to fundamental rights. This also brought a complete neglect of the principles that promoted socio-economic ideals of the society. The legislature was dissatisfied with the judiciary's version and understood it to be opposed to what the framers of the Constitution had originally assumed. It therefore seems probable that for the legislature, fundamental rights were to support the directive principles and not vice versa. This approach brought newer interpretations of the relationship between fundamental rights and the directive principles, in many occasions projecting a more comprehensive and harmonious image. In Chandra Bhavan Boarding and Lodging versus State of Mysore 1969, the Minimum Wages Act 1948 was challenged for conferring unobstructed, unregulated and arbitrary power on the state concerning the minimum wages. The state argued that it was compelled to recommend for minimum wages in accordance with the directive principles. The court held that the provisions of the Constitution were produced to assist progress as anticipated by the preamble, and it would be fallacious to take for granted that the Constitution provides only for rights and no duties. Furthermore, it was affirmed that even though Part 3 encompasses fundamental rights, Part 4 was necessary for the governance of the country and was therefore accompanying to each other. In essence, Part 3 and Part 4 are to be seen as one. This view was reaffirmed in case of Nanda Bharati versus State of Kerala 1973, a much celebrated case, where it was held that the directive principles were in synchronization with the country's aims and objectives, and the basic rights could be amended to convene the needs of the hour, implying that parts 3 and 4 needed to be amicably construed. Although these judgments were more vibrant in comparison to the previous approach that the Apex Court had taken, it still did not satisfy the ideals of the legislature. It could easily be speculated that the 42nd Amendment in 1973 was to accord primacy to the directive principles over the fundamental rights. This resulted in the question of resurrection on the relationship between fundamental rights and the directive principles. In Minerva Mills versus Union of India in 1980, the court alleged that the harmonious relation between fundamental rights and directive principles was an essential feature of the Constitution. It was stated that Part 3 and Part 4 together comprise the foundation of the Constitution, and any legislation or amendment that shatters the balance between the two would be an infringement on the basic structure of the Constitution. Chief Justice Chandrachud reasserted that Parts 3 and 4 are complementary to each other, and together they constitute the human rights of an individual. Reading these provisions separately would be unfeasible, as that would cause to be incomplete and thereby inaccessible. However, this was not established as law yet. In Sanjeev Coach Manufacturing Company versus Messrs. Bharat Coking Coal Limited in 1983, the Supreme Court apprehended that the part of the Minerva Mills judgment that dealt with Article 31C of the Constitution was simply obiter dictum and therefore not requisite. The court thus upheld the Coking Coal Mines Nationalization Act 1972 by conceding greater importance to the directive principles than fundamental rights, in accordance with Article 31C that provided for the same. The Sanjeev judgment resulted in a divergence of opinion, which was ultimately settled in state of Tamil Nadu versus Abu Kavir Bai in the year 1984. The court referred to the conclusion in the case of a constituent assembly to craft two parts for these foundational constitutional concepts. It was declared that the use of two distinct chapters was to grant the government adequate autonomy and flexibility to put into practice the principles depending on the time and state of affairs. The court consequently considered the Minerva Mills case as standard and recommended a harmonious construction of the two parts in civic interest and to endorse social welfare. This view has been constantly adopted ever since and has been sanctioned by Mohini Jain versus State of Karnataka 1992 and Unni Krishnan versus State of Andhra Pradesh 1993. Friends, it can therefore be construed to be well settled that a harmonious interpretation of fundamental rights and directive principles is essential in ensuring the social benefit. We can thus conclude by saying that although appearing to be established that there is a requirement for stability and harmony in interpreting fundamental rights and directive principles, this discourse is far from above. It is believed that in the midst of the advent of judicial activism, that the opinion of the court may alter in due course on occasion. The courts often have played a practical role in facilitating socio-economic improvement at a macro level, which requires cooperation on a micro level. Therefore, in light of the benefit of the society at large, the directive principles can be used to resolve the extent of public concentration, to limit the range of fundamental rights. And therefore, we have to consciously follow the judicial precedent. Friends, with this, we have come to an end of this lecture. I thank you for your patience hearing.